On March 12, 2018, attorney Robert Abrams gave a videotaped deposition in Denver, Colorado, in connection with a pending civil lawsuit against his firm, Abrams and Associates. Thomas Vera appeared on behalf of the plaintiff, while Neil Sullenberger represented the firm. The deposition was taken on the record and preserved on video.
As you know, my name's Tom Burge. I'm counsel for plaintiff Justin Moskowitz in this lawsuit. And do you understand why you've been asked to give your deposition today?
No.
Are you aware that your firm, Abrams and Associates, is a defendant in a lawsuit that's going to trial next month?
Yes.
And are you aware that you are a witness regarding the actions of Abrams and Associates?
Yes.
Have you had your deposition taken before?
I think so.
When have you had your deposition taken before?
I don't recall.
How many times?
I don't recall.
You're sitting here today under oath. You have no idea whether you've been deposed before?
I've answered that question. Object to form. Move on.
Mr. Abrams, have you been deposed
Object to
before?
form.
Object to form. Move to certify the question. If you feel that I haven't answered, then you can move for a sanction.
We're going to go ahead and stop the deposition at this point and dial the special master.
Would you be prepared to read back my answer to the special master regarding counsel's questions as to whether or not I answered that question?
Good morning. Could we speak with David Tenner, please?
Let me check and see if he's good. May I ask this caller?
Thank you. Yes, these are the parties from the Moskowitz versus Dahlman matter, and we are in the middle of a deposition this morning.
Okay, hold on just a moment.
Thank you.
He is not in the office at the moment. Can I get a number and have him call you back?
Yes, that would be great. If you could please.
Okay, I'll send him an email right now.
Appreciate it.
You're welcome.
Bye-bye.
Mr. Vera attempted to contact the special master to resolve the dispute over whether Mr. Abrams was required to answer the question, but the special master was unavailable. A special master is a neutral third party appointed by the court to manage and resolve specific issues in a case, including discovery disputes. Under Rule 53 of the Colorado Rules of Civil Procedure, a district court may appoint a special master to perform duties agreed to by the parties or to address matters that would otherwise consume significant judicial resources. In this instance, Mr. Vera called the special master in an effort to resolve the issue immediately without suspending the deposition or filing a formal motion with the trial judge.
If you laugh at me one more time, we're going to walk out.
We're going to move for 30D3 sections.
We're going to move for harassment sanctions against you right now. Okay, you're laughing at us with the videotape that you published on the internet about you and your rock band, and you're going to be laughing at me. And you've moved for sanctions and had them denied every single time in this matter, and the jury should see that too. Every single one has led to no sanction.
Mr. Abrams, are
including
you
the last
aware?
one where we quashed all of your subpoenas. And you asked for attorney's fees and you got no sanction.
Mr. Abrams.
Let's move on. Do you have a question for me? You sued my firm belligerently under the abuse of your law license, where we countersued you. We have a counterclaim against you for abuse of process for misusing your law license. You sued me for fraud, conspiracy, which is a criminal act, so you did that wrong, and aiding and abetting, which is a criminal act, so you did that wrong. Ask me questions about that or I'm leaving.
Mr. Abrams, we're going to be here for a long time today if you do not answer my questions. I just want to let you know that right now.
Object to form.
And put that on the record. Mr. Sullenberger, I'm sorry.
Stop laughing at my lawyer.
This is bizarre.
Stop laughing at my lawyer
Bizarre.
and stop harassing us.
Listen,
You brought us down here for fraud. Ask us fraud questions.
Mr. Abrams, how many times has your firm been added as a defendant in any lawsuit?
As I can recall, one in the BB matter.
So the BB matter and then this matter as well? Those are the only 2 times you recall that your firm has been added as a defendant?
Yes, as I recall.
Aside from traffic tickets, have you ever been named in a criminal action?
Objective form.
Objective form and privilege, so I assert privilege and need not answer.
What privilege are you asserting, sir?
Attorney-client privilege, and we would, under the law, I need not answer that.
What law are you referring to, Mr. Abrams?
I need a law book. And I move to strike, and I move for, I move to strike the question. I refuse to answer under privilege, and I move for a protective order on the question. So certify the question and move on.
You've again not answered my questions. You've made a absolutely baseless assertion of privilege. Are you aware that in a deposition, the proper objections that your lawyer are allowed to make are as to form and as to foundation? If there is a matter that's privileged and your lawyer objects to it on the basis of privilege, he can instruct you not to answer. Otherwise, you need to answer all of the questions that I give to you today. Do you understand that, Mr. Abrams?
He's raising an objection to privilege.
Mr. Abrams and Mr. Sullenberger informed Mr. Vera that they intended to seek Rule 30D3 sanctions under the Colorado Rules of Civil Procedure. Rule 30D3 permits a party or deponent to seek court intervention during a deposition if the questioning is conducted in bad faith or in a manner that unreasonably annoys, embarrasses, or oppresses the witness. If demanded, the deposition may be suspended long enough to present the motion to the court. Mr. Abrams argued that Mr. Vera was harassing him by asking about a prior lawsuit in which he had been a defendant, claiming the information would be inadmissible at trial. However, Rule 26 allows discovery into relevant matters, even if the information would not ultimately be admissible in evidence. Prior lawsuits could relate to credibility or lead to other discoverable material, making Mr. Vera's questions consistent with routine discovery rather than sanctionable conduct under Rule 30D3.
You are not answering the question today. You're refusing
Object to
to
form,
answer it,
object
Mr.
to
Abrams.
privilege.
Move on.
Move on.
It's the answer. Objection, privilege. Move on.
What privilege are you asserting today, Mr. Sullenberger?
Attorney-client privilege. He's already answered the question.
So Mr. Abrams is saying he has an attorney-client privilege over himself being named as a criminal defendant.
Yes.
And the question's intended to harass and annoy. And under 30D3, again, we're going to move for sanctions for repeated conduct like this.
I can't even get through my initial questions here because you are being so obstructionist
That's
today.
because you're a weak lawyer, but go ahead. You sued me for fraud. Ask me fraud questions. You sued my firm for fraud, aiding and abetting, and conspiracy. You have no evidence. Put something in front of me and we'll answer the questions. You have nothing. You have nothing.
Mr.
Put
Abrams,
something in
are
front
you
of me.
aware that Judge Starrs already ruled that there is substantial evidence against your firm that you committed fraud?
Object to
for misrepresentation of the
Are you
evidence,
aware?
Mischaracterization. The fact that the judge let you bring your bogus claim against us doesn't mean that it's merit full. Do you have a fraud question for me?
Please answer the question.
He just
again.
did. Ask him.
I did.
Are you
We're
aware?
Yes, I'm aware. Move on.
Mr. Abrams, have you ever been arrested?
Object to form and privilege, attorney-client.
That's it.
And you're instructing your client not to answer that question on the basis of attorney-client privilege, Mr. Sullenberger.
It's my understanding that Mr. Abrams had an attorney for any issues that may have arisen, and therefore he can assert.
I also don't recall being arrested.
What part of my question asked for any attorney-client privilege?
He's not being
communications?
deposed.
I don't have to, I objected. I
We're not
objected to
asking
form. I objected for privilege for Mr. Abrams.
I am going to end this deposition now.
Okay.
Mr. Abrams, we're going to continue it while we seek intervention of the special master.
Fine.
It's clear that you are not here to answer any questions
clear that
today,
you're harassing
and
us.
you are refusing to answer
We've
any of the
answered
questions
every question,
today.
read every question back.
Yeah, you have not.
We disagree.
Mr. Abrams repeatedly refused to answer Mr. Vera's questions after objections were raised. But an objection during a deposition does not automatically excuse a witness from responding. Under Rule 30C of the Colorado Rules of Civil Procedure, objections are preserved on the record and the examination continues. A witness must generally answer unless counsel properly instructs them not to. Rule 30D1 requires objections to be stated concisely and in a non-argumentative manner. An instruction not to answer is permitted only to preserve a privilege, enforce a court-ordered limitation, or present a motion under Rule 30D3. Outside of those narrow circumstances, the witness must respond. Accordingly, Mr. Abrams was obligated to answer most, if not all, of Mr. Vera's questions, despite the objections. Moreover, Rule 37 authorizes sanctions when a deponent refuses to answer or provides evasive or incomplete responses. His repeated refusals therefore exposed him to potential sanctions for obstructing discovery.
Okay, let's ask a couple more questions. Mr. Abrams, what are the pills that you just took? during this
Object to
deposition?
form.
None of your business. None of
Privilege.
None of
What are
your
those?
business.
What are those other pills? in front of
Object to
you?
form.
of your business.
Object to privilege.
None of your business.
Medical privilege. Don't
Mr.
have-
Abrams, are you under any any drugs today? Have you taken any drugs before you came to this deposition today?
No.
Okay. Have you taken any alcohol before you came to this deposition today?
No.
Any medication whatsoever?
No.
No. Just these pills that you're taking here?
Yes.
That you are refusing to answer what they are?
Yes,
Medical
none of your
privilege.
business.
Okay.
But I can tell you that if you took some of these, they would help get some of your weight off. I can tell you that.
Oh, you're referring to when you called me fat when you walked in here.
Object to
I don't recall
form.
that.
You don't recall that? Okay. Well, we have a couple of witnesses to that, including Mr. Sullenberger. In any event,
If you want to raise your weight problem, Mr. Ward, with the jury and with the special master, please do. But we're not the ones that are sitting here in that condition.
Mr. Abrams, do you recall the motion to quash the subpoena for your testimony
Yes.
that you filed? And you attempted to quash the subpoena to disallow your deposition to be taken, correct?
Object to form.
I don't recall that. I remember we successfully quashed your bad faith depositions. You moved for attorney's fees and you were denied by the special master. That's my recollection, that he found them, that he found them when we told you I would be out of town to, in bad faith, then schedule the deposition to pull me out of my vacation. He found that to be objectionable and he commended me on taking a vacation under the stresses of this profession. So I remember the special master commending me and quashing you. That's my recollection.
Are you here today pursuant to the subpoena?
Yes.
Okay. So your subpoena didn't get quashed, did it?
Yes, it did.
Sure didn't.
Yes, it did. Argumentative. Move on. What are you
and-
laughing at?
and-
Why do you keep laughing? What is it with you? Why don't you look at the camera and laugh at them?
Mr. Abrams,
Your
testimony is being taken
Just
today.
ask me some questions about fraud, civil conspiracy, and what other trumped up things you did under your license that we're moving for sanctions against you. Do you realize we sued you for abuse of your law license? Do you realize that? And that we're going to continue to sue you for the way that you've been treating in this matter? You have no evidence. If you do, show the jury, put it in front of us, we'll ask questions. You haven't put one document in front of us. Open something up and make this a meaningful deposition or let me go.
Is there anything else you'd like to say, Mr. Abrams?
Depends on what your next question is.
In the motion that you filed to quash the subpoena, isn't it true that you admitted to the special master that you were in fact in town?
Object to form.
We told the special master in a pleading that I returned at home at 3:30 in the morning on the same day that you scheduled my deposition, and that there was no way I was going to be able to come to the deposition with no sleep.
So you were in town at the time, you were in town on the time that you were scheduled to be deposed, but you
Object to
nevertheless moved to
form.
Asked and
quash.
answered. Move on.
Mr. Abrams, are you refusing to answer?
I answered
Object
the
to
question.
form.
Move on.
You don't get to not answer when you object.
Object to form.
Do you understand?
I answered the question, and I even told you what time I returned on the day. What more? Why are you harassing me?
Mr. Abrams,
stop harassing
listen
me.
to my questions. Today, that your job is to listen to my questions and answer your questions under oath. Do you understand?
Objection
Object to form.
asked and answered. Move on.
I'm waiting for your answer, Mr. Abrams.
Her first question was the same question you asked. If we need to go back to the very beginning to ask whether I said I would be here under oath, we can go back and ask the court reporter.
Mr. Abrams, in that motion, you included that Mr. Abrams' anxiety requires him to take medication on extended flights that impairs Mr. Abrams' facilities. Can you please explain what medication you were referring to in your filing?
Object to form
No.
medical privilege.
Privilege.
Medical privilege.
Yes. Move on.
you have
What privilege is that?
None of your
Absolutely
business.
no right.
No, what medicine I take is none of your business. Move on.
You filed a motion with the special master saying that because of a certain medication that
Yep.
you take, you could not sit for your deposition.
Yes, that medicine's none of your business. Move on.
And now
Objection,
you've
privilege.
come into this deposition today with a handful of pills
Yep.
that you refuse to answer questions about
Yes,
what they are.
None of your business. HIPAA protection privilege. Move on.
We are going to continue this deposition now, Mr. Abrams.
Okay.
You have made it clear you are not willing to answer any of the questions today. You have been objecting. We are going to move for sanctions against you and your firm for your conduct during this deposition, and we will take that up with the special master.
And will represent your conduct during this deposition as well.
Please do.
For the record, since the moment we've walked in here, I and my counsel have answered every single question and rightfully asserted 30D, I think it's
30D3.
for harassment. We've answered every single question. We've asserted privilege where counsel refused to accept privilege. And we've been nothing but harassed under 30D3. We're moving for sanctions. We're moving to quash the deposition for future. And we're here to answer all of the questions regarding why my law firm was surreptitiously brought into this lawsuit for fraud, conspiracy, and aiding. And he hasn't asked one question in furtherance thereof.
We will
Until he
continue
does,
all three of the
we will
depositions
move
that
to
are scheduled
strike.
for today because it is very clear that Mr. Abrams, Mr. Sullenberger, and their firm intend to obstruct discovery in this matter and do not intend to answer the questions today. We will ask that it be reconvened before the special master with Abrams and Associates to pay the full amounts of everything associated with the depositions, including the special master's fee. And we will be filing a motion to take that up with the special master today.
We disagree. We're filing the exact same motion and seeking the exact same sanctions. Anything else?
After the deposition, the court-appointed special master reviewed the transcript, sanctioned Mr. Abrams, and personally presided over his second deposition. On April 30th, 2020, his law license was suspended for 1 year, with 90 days to serve and the remaining 9 months stayed pending successful completion of a 2-year probation. Disciplinary authorities found that he repeatedly disrupted and prematurely ended his own deposition, continued representing co-defendants despite a conflict of interest without informed written consent, violated court orders regarding decorum and discovery, and submitted an affidavit containing inaccurate information. The findings also described confrontational conduct during trial that resulted in a restraining order against him. This was not an isolated incident. In 2020, he received a stayed 3-month suspension for sending clients a derogatory email about a judge and billing them for time spent responding to their disciplinary complaint. In 2021, he was publicly censured for entering into an improper lien arrangement, failing to obtain informed consent, and mishandling disputed client funds. In 2024, he was suspended again, 18 months with 6 to serve, for misconduct stemming from a fee dispute, including pursuing a default judgment despite defective service, confronting a represented former client, and posting derogatory online comments disclosing representation-related information. This deposition illustrates how civil discovery breaks down when participants disregard procedural rules. A witness does not choose which questions to answer, and attorneys are not exempt from those obligations. Disputes are resolved by the court, not through obstruction on the record. Here, the deposition became less about facts and more about conduct, with consequences that extended well beyond a single proceeding and ultimately damaged Mr. Abrams' professional standing. Let us know in the comments if there's another case or courtroom interaction you'd like us to explore.